sometimes you have to concede the obvious.
And I think, Judge, that...
And this is kind of a global question. I know you want to talk about each one individually, and we can do that, but
Well,
you can
I'm
address it
actually here to
globally.
answer any questions you have. So, but with respect to that, I do think that over the course of this investigation and the management of the complaint, the hearings, et cetera, Judge Sims has testified multiple times in connection with these hearings through the commission hearing, the hearing officer commission, the hearing officer hearing, those types of things, as well as some statements prior to that. And at every turn, she's indicated that takes responsibility for certain things as they happen along the way in connection with her management of things. The commission dissent and some of the language in the commission, it gets to the point of, okay, well, you should have been more remorseful. And I would suggest to you that Judge Sims has made every effort to acknowledge responsibility for those circumstances which she considered and which in fact were either a potential violation of the canons of ethics or things that she did not believe were up to her own standards.
Mr. Helmers, based
yes, sir.
on that belief that your client says, I want to take responsibility, what do you believe is the punishment that should be imposed?
And I think if you look through to the Chasson factors, Ms. Beatty went through them in some detail. You know, we have suggested in connection with the briefing that we filed in this case, in light of the history, the prior discipline history, that we would suggest a sanction in the event one was determined to be warranted of up to 60 days. For Judge Sims. And part of that is based on the fact that a lot of the issues that have been raised here in connection with her management of courtroom issues, either through evictions or through criminal issues, are determinations that she made in the context of a good faith effort to discharge her judicial duties. And Chasson specifically indicates that that is supposed to be considered in connection with the determination of any type of discipline that would be warranted or meted out by this court. Every violation of a canon of ethics is not a disciplinary offense. It's not something, you know, that you may violate the canons in certain respects, but this court has previously indicated in Fusilier that that's not always going to be something that would warrant discipline. And when you're dealing with individual circumstances, I think you have to look at factually each one of them. And there are specific issues as to why certain things occurred in connection with this. And if you look, for example, at the demeanor claim, which Ms. Beatty spent a lot of time on, and which forms the basis for the commission's idea, well, that there's a pattern here, there's a long-term history of misconduct. On the front end, the commission looks at count 2 and says that's not proven. And count 6, which was a count against this judge for the entire tenure of her history as a judge in Shreveport City Court. They come and they say, well, she's always rude or disrespectful. Even the hearing officer and the commission said, not proven, and we relied upon multiple witnesses in connection with that issue relative to judicial assistants, litigants who appeared before her, clerks who were in her court on a daily basis as to whether she exhibits a demeanor that's improper. And the uniform indication was not only no, but the hearing officer specifically indicated that she is fair, firm with litigants, no question about that, but makes every effort to handle things in a manner that's fair, impartial, and she's willing to engage the facts to address some of those issues. With respect to the Everett claim, which was count 1, that's an eviction proceeding. And just, you know, using some of the numbers over the, you know, Judge Sims has estimated in her hearing testimony that she has handled between 15 and 20,000 evictions. So the issue before you involves 2 of them. The first one is this Everett matter. And we would suggest to you that the hearing officer, Judge Gil Jefferson, in connection with the handling and the management of the Everett eviction, Judge Gil Jefferson got it right. She made the determination that the testimony demonstrated by clear and convincing evidence that there was a credibility and a veracity issue with Ms. Everett as a witness. And Judge Sims made an attempt to make a determination whether or not the eviction should be granted under those circumstances. There are issues with respect to, was there an authorized pet? Was there a pet deposit? Was there unauthorized vehicle on the property? All of those issues, as it became clear that that was going to be a problem and it was going to take longer, she had them sit down. They came back up. The issue was still in play whether or not Ms. Everett was being truthful with her, and this judge has an obligation to go through and make a determination on the merits of the case, who's being honest with me. And she made an effort to do that. She's admitted, well, maybe I could have been more courteous in connection with the handling of that, but my job is to determine who's being honest with me in connection with the litigants before me. And Judge Jefferson fairly indicated that was what she did. The commission relies upon the handling of that matter toward the end when Judge Sims asked the litigants to come back up in order that the tenant could tender the payment for the rent. And Judge Sims asked him to come back up. Ms. Everett turned her back, wouldn't turn around, and then her voice got raised. And Judge Sims fairly is getting concerned about whether she's respecting the judiciary at that point. So the handling of that matter clearly does not demonstrate a violation of the canons of ethics. What
about requiring her to accept the payment for the rent?
I think that under those circumstances, Justice, if you recall, the record indicates that there was a prior arrangement between the tenant and the landlord to meet in order that the tenant could tender the rent. Ms. Everett didn't show up. Because she didn't show up, the tenant went into default. And so there was a legitimate concern about whether or not, if they make an arrangement outside of court in order for this guy to bring the rent, well, is she going to show up then or not? And so, yeah, she said, ask them to tender.
That's a matter of evidence you take into account deciding whether there's a default. But when you order a creditor to accept a payment, that's rather extraordinary, don't you think?
I think the testimony indicates that she directed the tenant to tender the rent. And there isn't.
You don't think you don't think the record indicates that creditor was feeling a little bit compelled to accept it?
Well, I think the credit.
What I read, I don't know what I wouldn't have been feeling like I was under the judge's thumb and I had to do it.
Well, I think certainly under the circumstances, given the factual scenario in that situation, the landlord had already skipped out on one occasion when the rent was intended to be tendered and there was an agreement beforehand. And Judge Sims, at that point, directed the tenant to tender it. In connection with the handling of that, I would suggest to you that, sure, maybe she could have been a little bit more courteous or something along those lines, but I don't suggest, I wouldn't.
My interest is not the courtesy, I mean, as much as just ordering somebody to accept a payment from somebody else. That's not a matter of courtesy or impoliteness. That's a matter